Hi there, Shalev here with your Arizona Lemon Law Advocates. And what I would like to talk to you about today is 4 lemon law ripoffs to avoid. So let's get to it. Number 1, never ever sign your rights away before speaking to an attorney. What can sometimes happen is you'll have a consumer who's having a problem with his vehicle or she's having a problem with her vehicle. In good faith, they call up the car company or the RV company. They try and work it out amicably with the company. And oftentimes what happens is the company frankly screws them. What the company will do is they'll offer maybe something very small like a month of payment or a short warranty extension. But guess what? That's not for free. What they have to do is they sign a release, signing all their rights away. And we've had consumers come to us who have very, very strong cases where they should be getting their vehicle bought back or they should be getting their vehicle replaced. And guess what? There's nothing we can do for them because they signed all of their lemon law and breach of warranty rights away. So never, ever do that. Never sign your rights away in exchange for minimal compensation or for a short warranty extension. Number 2, never, ever leave a repairing dealership without being given a repair record. It's called a repair order. Sometimes what will happen is people will take their vehicle into the repair shop and they'll reprogram a computer module or they'll do some kind of repair, but then they don't provide any repair record. And then what happens is by the time that the consumer comes to us, all of a sudden records disappear. All of a sudden the dealer's claiming that the consumer never went there to get a repair. So never, ever, ever leave a dealership without a repair record if you're getting your vehicle fixed. Even if they don't do a repair, still demand a repair record. The reason is because if they don't do a repair, they say they can't find the problem. But then you go and get a repair after that, then you can argue that the first time was a misdiagnosis and it's still a repair attempt that counts towards the lemon law. Number 3, never ever sign a representation agreement, an out-of-court representation agreement for a lemon law case that charges you. Now there's multiple ways that you can be charged for out-of-court representation by attorneys. It's not appropriate for them to charge you because most lemon laws, including the Arizona lemon law, allows consumers to recover attorney's fees from the car company. So the attorney should not be charging you. So there's a contract where an attorney could ask for a retainer. That means you pay them money up front to take on your case. They keep the money no matter what happens in the case. So even if they get you nothing, they get to keep your money. Never agree to that. The other way that a consumer could be charged is they're not charged up front, but in the contract, there's all kinds of ways where a consumer can be charged. For example, if they're not responding to calls or emails quickly enough, if they accept a certain type of settlement, they could be charged. So don't agree to that either. Do not agree to be charged out of court. The third way that a consumer can be charged out of court is if the car company does not offer to pay the full flat fee attorney's fees. Most of these cases are handled on a flat fee basis out of court. So what some attorneys do is if the car company doesn't offer the full flat fee for the attorney says, hey, well, if you accept this buyback or replacement, I don't get paid my full fee. Guess what? You either got to pay me that fee out of your settlement, out of your refund, or if it's a replacement, you got to pay me that out of pocket. There's also a situation where out of court, there could be a small settlement offer and the attorney's fee will try and take a larger flat fee than what you get. So that's not fair either. You know, an upfront and upright attorney should agree to split that type of settlement offer in half with you if you don't want to go to court. Number 4, do not go through alternative dispute resolution prior to getting an attorney or prior to seeking resolution of a lemon law issue. Now what that is, there's basically 2 arbitration methods in this state, and that is the BBB auto line, paid for by car companies, and also the NCDS, paid for by car companies. Let's say you went to court. The judge is paid for by the other side. Who do you think the judge is going to favor, especially if it's a close call? Oftentimes, people will go through the BBB auto line. They have a valid case. There's a ruling against them, and so they think, well, gosh, I guess I don't have a valid case. A huge number of times, or a huge percent of the time, the arbitrators unfortunately rule against them. And it makes sense because guess who the arbitrator is paid for? He's paid by the car company. So that is 4 lemon law ripoffs that you should always avoid. Please contact us for a free, no obligation case review if you're having a lemon law issue. We're here to help.